Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or tax advice. Divorce law and retirement account regulations are subject to complex state and federal statutes that have evolved significantly over time. Historical trends and case studies discussed are for illustrative purposes and do not indicate potential outcomes for your specific situation. Always consult with a qualified attorney or a certified financial planner before making decisions regarding asset division or retirement planning. Conduct your own due diligence. Imagine working for 30 years, diligently pouring a portion of every single paycheck into a black box labeled for your future, only to watch a judge's gavel split that box in half in less than 30 seconds. In the late 20th century, millions of Americans woke up to a brutal reality. The 401k, once marketed as the ultimate tool for personal rugged individualism, had become the most contentious battlefield in the American courtroom. We are talking about the era where the silver tsunami of divorce met the golden age of the 401k, creating a perfect storm that redefined the middle-class dream. By the end of this deep dive, you will understand exactly how the shift from traditional pensions to defined contribution plans fundamentally changed the leverage in American households, why the 1980s and 90s saw a revolution in qualified domestic relations orders, and how the mistakes made by a previous generation are still costing retirees billions of dollars today. If you want to protect your legacy, you have to understand the history of how it was first taken apart. To understand the 401k divorce, we first have to understand the monumental shift in how Americans saved for the future. Before the late 1970s, the defined benefit plan, or the traditional pension, reigned supreme. If you worked for a company like General Motors or IBM, you were essentially promised a monthly check until the day you died. In a divorce scenario during the mid-20th century, these pensions were often treated as future interests, or even ignored entirely because they had no immediate cash value. They were theoretical. But in 1978, a quiet provision in the Internal Revenue Code, Section 401k, changed everything. Suddenly, the future interest became a defined contribution. It was a pile of cash with a daily ticker symbol, and it was growing. By the mid-1980s, the 401k was no longer a niche corporate perk. It was the primary vehicle for American wealth. This created a massive legal vacuum. If a husband had $200,000 in a 401k and the couple decided to split, how do you move that money without the IRS hitting you with a 10% early withdrawal penalty and a massive income tax bill? For several years, the system was in chaos. People were trying to divide these accounts like bank accounts, only to find that the anti-alienation provisions of ERISA, the Employee Retirement Income Security Act of 1974, prohibited the movement of funds to anyone other than the employee. This meant that even if a judge ordered the split, the plan administrator's hands were tied by federal law. The resolution came in 1984 with the Retirement Equity Act. This was the birth of the QDRO, or the Qualified Domestic Relations Order. This single legal document became the skeleton key of the late 20th century divorce. It allowed for the creation of an alternate payee, usually the non-employee spouse, who could receive a portion of the 401k without triggering the standard penalties. However, the introduction of the QDRO didn't make things simpler. It made them infinitely more dangerous. We began to see an era of financial archaeology, where lawyers had to dig through years of statements to determine what was separate property versus marital property. Consider a typical case study from 1992. A couple is divorcing after 20 years. The husband started his 401k 3 years before the marriage. In the eyes of the law, those first 3 years of contributions, and the compounding growth on those specific dollars, might be his separate property. But how do you calculate the growth of a specific $5,000 deposit from 1979 versus a $10,000 deposit from 1985 in a volatile market? This led to the rise of forensic accounting and divorce. It wasn't just about splitting the pie. It was about proving who owned which slice of the flour and sugar that went into making the pie. During this period, the emotional stakes were higher than ever because the 401k represented the only safety net. Unlike the 1950s, where a divorced woman might be left with no claim to a husband's future pension, the 1980s and 90s saw women fighting for their share of the portable wealth. This shift mirrored the broader social changes in America, as more women entered the workforce and began contributing to their own 401ks. We saw the emergence of offsetting, a strategy where one spouse would keep the house while the other kept the 401k. On paper at the time it looked like a fair trade, $150,000 in home equity for $150,000 in a retirement account. But this is where the late 20th century trap was set. Those who took the house often realized too late that they had a high maintenance, illiquid asset that didn't grow at the rate of the S&P 500. Meanwhile, the spouse who kept the 401k benefited from the massive bull market of the 1990s. Historical trends show that by the year 2000, those who chose the 401k over the real estate often ended up with triple the net worth of their former partners. This period taught us that in a divorce, not all dollars are created equal. A pre-tax dollar in a 401k is fundamentally different from a post-tax dollar in a savings account or the equity dollar in a suburban home. As we moved into the late 90s, the complexity deepened with the introduction of loans. Many Americans began treating their 401ks like personal ATMs, taking out loans for down payments or car purchases. In a divorce, these loans became a nightmare. If a husband took a $40,000 loan from his 401k to renovate the kitchen, and then the couple divorced, who owes the 401k back? If the loan isn't repaid, it's considered a distribution, subject to taxes and penalties. Suddenly, a simple asset split became a liability negotiation. Lawyers had to decide if the balance of the account was the total amount including the loan, or just the liquid cash remaining. We also saw the rise of the valuation date controversy. In a market that was swinging wildly during the dot-com boom, the difference between valuing a 401k on the date of separation versus the date of the final decree could mean a difference of tens of thousands of dollars. If the market dropped 10% during the 6 months it took to finalize the paperwork, who bears that loss? The late 20th century was a masterclass in the volatility of timing. This history is vital for you today because the precedents set in the 80s and 90s are the exact rules we live by now. The QDROs drafted today are descendants of the messy trial-and-error documents of 30 years ago. By studying how the 401k went from a secondary thrift plan to the primary bone of contention in American households, you gain a perspective on how to view your own assets, not as a monolithic pile of money, but as a complex web of tax liabilities, marital claims, and historical growth. We are going to examine the specific data points of how these accounts were divided, the common pitfalls that led to accidental poverty for divorcees, and the step-by-step evolution of the legal strategies used to protect, or pillage, the American retirement dream. To truly grasp the gravity of the 401k divorce in the late 20th century, we have to look at the mechanics of the 1984 Retirement Equity Act, or REA. Before this federal intervention, the retirement landscape was essentially the Wild West. Imagine you are a spouse in 1982 named Linda. Your husband, Robert, has been working at a manufacturing plant for 15 years. He has a significant 401k balance. In the eyes of the plan administrator at that time, Linda basically did not exist. If Robert wanted to name his brother as the beneficiary or withdraw funds, he often could do so without Linda ever receiving a notification. The REA changed the DNA of American marriage by mandating that a spouse had a legal right to these benefits, but it also created a bureaucratic maze that lawyers are still navigating in 2026. The center of this maze was the concept of the marital portion. In a masterclass on this era, we have to talk about the coverture fraction. This is the mathematical formula that determined how much of that 401k was actually up for grabs. Imagine Robert started his 401k in 1978, got married to Linda in 1983, and they filed for divorce in 1998. The court had to look at the total months Robert participated in the plan versus the months he was both in the plan and married. This sounds simple on paper, but the late 20th century saw the introduction of massive market volatility and employer matching programs that made the math a nightmare. If the company matched 50 cents on the dollar only after 5 years of service, does that match belong to the period before or after the wedding? These were the questions that led to legal fees occasionally swallowing 20% of the account value before a single dollar was even moved. One of the most significant historical trends during this period was the move toward immediate valuation. In the early 90s, the courts began to favor the idea that a 401k should be valued on the day the divorce summons was served. However, because the 401k was an active investment account, its value changed every second. Imagine if the summons was served on a Monday when the Dow Jones was at a record high, but the final judgment wasn't signed until a Friday after a massive market correction. One spouse could end up being awarded a dollar amount based on a balance that no longer existed. This forced the legal industry to move toward percentage awards rather than fixed dollar awards. Instead of saying Linda gets $50,000, The court started saying Linda gets 50% of the marital portion as of the date of distribution. This shift protected both parties from market swings, but it introduced a new level of complexity for the plan administrators who had to do the math. Then came the issue of the tax trap. In the late 20th century, many couples tried to settle their divorces by having the employee spouse simply withdraw the money and give it to the other. This was a catastrophic mistake. Under the tax codes of the time, that withdrawal was treated as 100% taxable income to the employee, plus a 10% early withdrawal penalty if they were under 59 and a half. We saw case studies where a husband would withdraw $100,000 to pay off his ex-wife, only to be hit with a $40,000 tax bill the following April that he couldn't afford to pay. The QDRO was the only way around this, allowing the money to move from Robert's 401k directly into Linda's IRA. This preserved the tax-deferred status, but it required a level of precision in the wording that many general practice attorneys simply didn't possess in the 1990s. One missing sentence about surviving spouse benefits or cost of living adjustments could render the entire document void. Let's look at a scenario involving a mid-level executive in 1995. He has a 401k, but he also has outstanding loans against it used to fund a family vacation and a new roof. In the divorce, the court treats the 401k as an asset, but the loan is a liability. If the 401k is worth $200,000 but has a $50,000 loan, the net value is $150,000. If the wife is awarded half, she expects $100,000. But if the husband leaves the company or fails to repay the loan after the divorce, that $50,000 is deemed a distribution. The IRS comes knocking for taxes on that $50,000. This created a situation where people were unknowingly inheriting their ex-spouse's tax debt. It was a period of financial landmines where the standard paperwork was often a recipe for disaster. Beyond the math, we have to discuss the hidden assets era. As 401ks became more common, so did the practice of loading the account right before a divorce. A spouse might suddenly increase their contribution to the maximum legal limit, effectively hiding marital income inside a retirement shell where the other spouse might not think to look. In 2026, we have sophisticated software to track these patterns, but in the 90s, it required a literal paper trail of pay stubs and annual statements. If a spouse was savvy, they could shift thousands of dollars out of the joint checking account and into their 401k in the months leading up to a split, betting on the fact that the other spouse wouldn't know how to calculate the premarital versus marital contributions accurately. Another critical factor was the survivor benefit oversight. In the late 20th century, many QDROs were drafted without specifying what would happen if the employee spouse died before the other spouse started taking payments. Imagine Linda is awarded half of Robert's 401k, but Robert passes away a year later before the funds are actually transferred. Without specific survivor benefit language in the court order, the 401k plan might simply revert the entire balance to Robert's new beneficiary, perhaps a new spouse or his children, leaving Linda with nothing despite her court order. This period was defined by these technicalities that had life-altering consequences. The sheer volume of 401k assets meant that by the late 90s, the retirement divorce was no longer just about the money. It was about the power of the timeline. This leads us to the most dangerous aspect of the late 20th century 401k split, the loss growth period. When a QDRO is filed, there is often a gap of months or even years between the date the divorce is final and the date the money actually moves. During that time, who gets the dividends? Who gets the interest? If the account grows by 15% while the lawyers are arguing over the phrasing of a paragraph, that growth could represent thousands of dollars. Historically, the spouse who held the account often kept the growth, effectively shortchanging the other spouse by stalling the process. This deep dive into the 1980s and 90s reveals a system that was struggling to keep up with the speed of financial innovation. The 401k was moving faster than the law. While the 401k was designed to give workers control over their future, in the context of a divorce, it often gave one spouse a massive information advantage over the other. But what happens when that advantage is used to intentionally crash the value of an account, just to keep a partner from getting their share? And how did the introduction of blackout periods during corporate mergers in the late 90s leave thousands of divorcing couples in a legal limbo where they couldn't even see their own money, let alone divide it? The complexity doesn't stop at the math or the taxes. It extends into the very psychology of how we value our labor versus our partner's contribution to the home. In the next part, we are going to look at the commensus movement and how the battle over 401ks led to a radical change in how homemaker contributions were valued in the eyes of the U.S. Treasury. We will explore the shocking cases where 401k balances were used as bargaining chips for child custody, and the dark side of ERISA preemption that allowed some employees to move their money out of the country entirely, leaving their families with a piece of paper that was worth less than the ink used to sign it. Why did some 401k plans refuse to honor state court orders altogether? And how did that lead to a Supreme Court showdown that changed the rules for every American worker? The answers lie in the fine print of the documents that most people never bother to read. To understand why some 401k plans could simply ignore a judge's order, we have to look at the concept of ERISA preemption. In the late 20th century, the Employee Retirement Income Security Act of 1974 became a shield for many corporations. The idea was simple. The federal government wanted to ensure that a company operating in 40 different states didn't have to follow 40 different sets of state laws. However, in the context of a 1980s divorce, this created a massive loophole. If a state court judge in Ohio ordered a company to hand over half of a 401k to a spouse, the company's lawyers would often argue that because the plan was governed by federal law, the state judge had no jurisdiction over the plan administrator. This led to the infamous legal no man's land, where a person could have a valid divorce decree, but absolutely no way to collect the money. This friction culminated in the landmark case of Boggs versus Boggs in 1997. This case was a watershed moment for American retirement law. Imagine a scenario where a husband, Isaac, was married to his first wife, Dorothy. They lived in a community property state like Louisiana. Dorothy passed away, and in her will, she left her share of Isaac's retirement benefits to their sons. Isaac later remarried a woman named Sandra. When Isaac passed away, a massive legal battle erupted. Did Dorothy have the right to bequeath her interest in a 401k or pension to her children under state community property laws? Or did ERISA's federal rules dictate that the surviving spouse, Sandra, got everything? The Supreme Court eventually ruled that ERISA preempted state law. This meant that the federal interest in protecting the retirement of the worker and their current spouse outweighed the state's interest in traditional inheritance. For many families in the late 90s, this was a wake-up call. It proved that your 401k wasn't just a bank account. It was a federal instrument that could override your own will and testament. The Boggs case highlights a critical historical trend: the absolute supremacy of the plan document. During the 1990s, if the language in your 401k plan document said that only a spouse could be a beneficiary, and you failed to update your paperwork after a divorce, your ex-spouse could legally collect your entire life savings, even if your divorce decree specifically said they waived all rights to it. This was the paperwork trap. Thousands of Americans learned the hard way that a divorce decree is a contract between two people, but a 401k beneficiary designation is a contract between an employee and a multi-billion-dollar financial institution. The institution will almost always follow the piece of paper in their file over the judge's order in your drawer. Let's look at a case study involving a character named Michael in 1998. Michael is a tech worker during the dot-com boom. His 401k is ballooning with company stock. When he divorces his wife Sarah, they agree that she will take the house and he will keep the 401k. However, the 401k contains unrealized appreciation on company stock. If Michael sells that stock to get cash, he's hit with ordinary income tax rates. But if Sarah had taken a portion of that stock through a QDRO, she might have been eligible for special tax treatment, known as net unrealized appreciation or NUA. Because their lawyers didn't understand the interplay between NUA rules and divorce, Sarah ended up with an illiquid house while Michael ended up with a massive tax liability that eroded 40% of the value he thought he was keeping. This highlights the step-by-step failure of many late 20th century settlements. They looked at the balance, but they never looked at the tax character of the assets. In the mid-90s, we also saw the emergence of the non-qualified plan problem. For high-earning executives, a 401k was often capped by IRS limits. To compensate, companies created top hat plans or supplemental executive retirement plans, SERPs. These were not governed by the same QDRO rules as a standard 401k. Because these were unfunded promises to pay, a spouse couldn't simply roll over their share into an IRA. They had to wait until the executive actually retired to get paid. Imagine being a spouse named Karen in 1996, divorcing an executive. You are awarded 50% of his retirement. You get your share of the 401k immediately, but his SERP, which represents 2/3 of his total retirement wealth, is tied to his employment. If he gets fired, or if the company goes bankrupt, your settlement vanishes. This created a massive disparity in leverage during negotiations. The worker spouse could essentially hold the non-worker spouse's future hostage by threatening to quit or retire early. This leads us to the valuation of the future debate. In a deep dive into this era, we have to talk about how courts struggle to value vesting. If an employee had $100,000 in a 401k, but only $50,000 was vested, how much belongs to the spouse? If the couple divorces today, but the remaining $50,000 vests next month because of the work done during the marriage, should the spouse get a piece of it? In the late 20th century, different states had wildly different answers. Some used the reserved jurisdiction method, where the court stayed involved for years until the money vested. Others used the immediate offset method, where the spouse was paid out a smaller, discounted amount today to settle the debt. This created a geographic lottery, where your retirement security depended entirely on which side of a state line you lived on. By 1999, the 401k divorce had become a weapon of psychological warfare. We saw the rise of the blackout period maneuver. When a company changes 401k providers, there is often a window of several weeks where no one can move money or change investments. Savvy litigants would time their court filings to coincide with these blackout periods, freezing their spouse's access to funds during the most critical part of the negotiation. This was the era where financial literacy became a survival skill. If you didn't know the difference between a participant and an alternate payee, you were essentially flying blind in a storm. Consider the early retirement subsidy trap. Some 401k adjacent plans offered bonuses for people who retired at 55. If a QDRO was written to give a spouse a portion of the normal retirement at 65, but the employee took the early retirement at 55, the spouse's share could be drastically reduced or delayed. This required the invention of the Gilmore election, a legal move where a spouse could demand their share of the retirement as soon as the employee reached the earliest possible retirement age, regardless of whether the employee actually retired. It was a move designed to stop an ex-spouse from working forever just to spite their former partner. The late 20th century was defined by these granular, high-stakes battles over definitions. Is a 401k income for purposes of child support, or is it an asset for purposes of property division? If you take a distribution to pay child support, do you still have to pay the 10% penalty? By 2026, many of these questions have been settled by tax court rulings. But in 1994, every single divorce was a potential test case for a new IRS regulation. But there is a darker side to this history that we haven't touched on yet. What happens when the 401k isn't just split, but is used as a tool for recapture? We are going to look at the alimony substitution era, where 401k transfers were used to avoid ongoing spousal support, and how this led to the poverty trap for older women in the early 2000s. And we must address the ultimate nightmare. What happens if the 401k plan itself is fraudulent? In the next part, we dive into the corporate scandals that wiped out marital assets overnight, leaving divorcing couples fighting over an empty box. We will examine the collapse of giants like Enron, and how the company stock obsession in 401ks turned thousands of divorces into total financial wipeouts. How do you divide a 401k that is worth $1 million on Tuesday and $0 on Wednesday? The answer changed American law forever. The transition from the late 1990s into the early 2000s exposed the ultimate fragility of the 401k as a marital asset, the concentration of company stock. To understand the wreckage of this era, we have to look at the historical trends of corporate culture in the late 20th century. Many major American employers didn't just offer a 401k. They incentivized or even mandated that the employer match be held in the company's own stock. For a couple in 1999, this felt like a wealth multiplier. If you worked for a titan like Enron, WorldCom, or Lucent Technologies, your 401k wasn't just a retirement fund, it was a rocket ship. In a divorce negotiation, this created a dangerous illusion of liquidity. Imagine a couple, David and Susan, finalizing their divorce in early 2001. David has been a loyal employee at a high-flying energy firm for 15 years. His 401k is valued at $1.2 million, but 85% of that value is tied up in company stock. During the settlement, Susan's attorney argues for a 50% split. They draft a QDRO to transfer $600,000 worth of shares to Susan's name. However, as we saw in multiple case studies from this period, there is a lag time between the judge signing the order and the plan administrator executing the transfer. During this specific window, the corporate scandals of the early 2000s began to break. By the time the plan administrator processed Susan's QDRO, the stock had plummeted from $80 a share to 80 cents. This created a legal crisis that shifted the way American courts view fiduciary duty in divorce. Because the 401k was an ERISA-governed account, the plan administrators often claimed they were powerless to stop the collapse or to expedite the transfer of funds. Susan is left with a piece of paper saying she is owed $600,000, but the account only contains $6,000. David, meanwhile, has lost his job and his own half of the retirement. This era taught us the brutal lesson of the diversification gap. In the late 20th century, many divorce decrees failed to include a liquidate and hold clause, which would have forced the account into a stable money market fund the moment the divorce was filed. Without this protection, thousands of divorcing Americans were forced to ride a sinking ship all the way to the bottom, losing decades of marital labor in a matter of weeks. The fallout of these corporate collapses led to a surge in litigation regarding the valuation date versus the distribution date. If the court orders a split of $500,000 on January 1st, but the money isn't moved until June 1st when the account is worth $200,000, who takes the hit? In the late 90s, the prevailing historical trend was that the alternate payee, the non-employee spouse, bore the risk of market fluctuations. But after the Enron era, courts began to see the inherent unfairness of this. We saw the rise of adjustment clauses, where lawyers began writing 401k splits that accounted for gains and losses during the administrative delay. This ensured that both spouses shared the risk and the reward proportionally, preventing one spouse from being wiped out while the other held onto a fixed dollar amount. Another deep dive layer of this era involves the fiduciary breach claims. In the wake of these 401k collapses, divorcing spouses began suing the companies themselves. They argued that if the company knew the stock was failing, they had a duty to warn the alternate payee, who was waiting for their QDRO to clear. These cases rarely succeeded due to the strict anti-alienation rules of ERISA, but they highlighted a massive flaw in the 401k system. The spouse was a legal stranger to the company until the very second the QDRO was finalized. For months, they were in a state of financial suspended animation, watching their future disappear on the evening news with no legal standing to sell the stock or move the money. This leads us to a critical step-by-step examination of the gains and losses calculation. During the late 20th century, many 401k plans were still using rudimentary accounting systems. When a QDRO was served, the plan administrator had to manually calculate the earnings on the specific portion being awarded to the ex-spouse. Imagine if David's 401k had 5 different mutual funds and one company stock. If Susan was awarded 50% of the total, the plan had to decide if she got 50% of each individual holding or just a cash equivalent. If the plan chose a cash equivalent, but the market jumped 10% the next day, Susan missed out on those earnings. This resulted in the shadow accounting industry, where forensic accountants were hired just to double-check the math of the 401k providers. In 2026, these calculations are automated, but in 1997, a misplaced decimal point in a 401k split could result in a $20,000 error that went unnoticed for years. We also have to address the loan default catastrophe that occurred during the 2000 to 2002 market downturn. In the late 90s, taking a loan against your 401k was seen as a smart way to access capital. But in a divorce, the loan is a ticking time bomb. If David had a $50,000 loan against his 401k, and he lost his job during the market crash, the IRS considered that loan distributed. Not only did he lose the $50,000 from his retirement balance, but he also owed $15,000 in immediate taxes and $5,000 in penalties. In a divorce settlement, the spouse often didn't realize that the balance they were splitting was artificially inflated by these loans. If Susan was awarded half of a $200,000 account that had a $50,000 loan, she might only receive $75,000 in actual cash, while being shocked to find that she was also liable for a portion of the tax hit on the defaulted loan. This period was also the birth of the QDRO mill. As the complexity of 401k law exploded, standard family law attorneys realized they were out of their depth. A single wrong word could lead to a malpractice suit. This gave rise to specialized firms that did nothing but draft these retirement orders. This added another layer of cost and time to the divorce process. A couple in 1998 might spend $5,000 just on the QDRO phase of their divorce, on top of their regular legal fees. This created a two-tiered justice system. Those who could afford the specialist to ensure their 401k was divided correctly, and those who used formed documents and ended up with ghost assets that they could never actually collect. The 401k divorce in the late 20th century was not just about the money, it was about the transition from a pension economy to an investment economy. In a pension world, the risk was on the company. In the 401k world, the risk was on the couple. And when that couple split, the risk became a weapon. We saw cases where a participant would intentionally shift their 401k investments into high-risk, junk options just to spite their spouse during the divorce, knowing that even if they lost money, the other spouse would lose just as much. This scorched earth financial strategy led to the creation of automatic temporary restraining orders, or ATROs, which are now standard in many states, preventing any changes to investment allocations once a divorce is filed. As we look deeper into the mechanics of these splits, we have to talk about the post-divorce contribution problem. If you divorce in June, but you keep contributing to your 401k through December, how do you separate the new money from the old marital money? In an era of high-growth tech stocks, the new money could be worth more than the old money by the time the paperwork was done. This brings us to the traceability nightmare. If you used your 401k to buy a house in 1992, and then you divorced in 1999, how much of that house is retirement, and how much is equity? But the most shocking aspect of this era isn't what happened to the money that was there. It's what happened to the money that was promised but never existed. We are going to explore the off-balance sheet retirement plans and the phantom shares that left high-earning spouses fighting over millions of dollars that vanished into thin air during corporate bankruptcy. And we must examine the Social Security offset debate, a controversial legal theory from the late 90s that argued if one spouse has a 401k and the other has a larger Social Security projection, the 401k shouldn't be split at all. How did this argument nearly destroy the concept of equitable distribution? The next part of this masterclass takes us into the boardroom, where the definitions of wealth were being rewritten in ways that would leave one spouse a millionaire and the other a ward of the state. What happens when the 401k isn't the biggest asset, but the deferred compensation is? The answer involves a secret set of rules that only the top 1% of earners even knew existed. The secret set of rules governing the top tier of American earners in the late 1990s centered around a vehicle known as the Non-Qualified Deferred Compensation Plan, or NQDC. While the average American was focused on their 401k, executives at major firms were parking millions in these shadow accounts. To understand the 401k divorce in its most extreme form, we have to look at how these plans differed from the standard retirement accounts we have discussed so far. Unlike a 401k, an NQDC plan is essentially an unsecured promise from an employer to pay an employee at a future date. In the eyes of the law in the late 20th century, this created a massive valuation problem. If a husband, let us call him James, had $5 million in deferred compensation but the company had the right to withhold it if he went to work for a competitor, what is that asset actually worth today? Imagine a case study from 1998 involving an executive at a telecommunications giant. James and his wife Patricia are dividing their estate. The 401k is a relatively small $300,000, but the deferred compensation is nearly $4 million. Patricia's legal team argues that because this money was earned during the marriage, it is a marital asset. However, James's lawyers argue that because the money is subject to a substantial risk of forfeiture, its current value is zero. This led to the historical trend of price-time probability modeling in courtrooms. Experts would testify about the likelihood of James staying at the company long enough for the money to vest. If the court awarded Patricia half of the future money, she became a creditor of James's employer. But here was the catch. If the company went under, Patricia had no ERISA protections. She was just another person waiting in line at a bankruptcy hearing. This brings us to the double-dipping controversy that peaked in the mid-1990s. This is a complex legal concept that every person dividing a retirement account needs to understand. Imagine James retires and starts drawing $50,000 a year from his 401k. The court uses that $50,000 to calculate how much alimony he should pay Patricia. But wait, the court also already gave Patricia half of the 401k principal in the property division. James's lawyers would argue that the court is counting the same money twice, once as an asset and once as income. This led to a series of conflicting state Supreme Court rulings. Some states, like New Jersey and Florida, developed strict rules against double-dipping, while others allowed it under the theory that the needs of the spouse outweighed the mathematical purity of the asset division. This created a strategic nightmare for couples. If you took the money as a lump sum through a QDRO, you might lose your right to ask for higher alimony later. The step-by-step complexity increased when we consider stock options as an adjunct to the 401k. In the late 90s, the Black-Scholes model became a household name in high-stakes divorces. This is a mathematical formula used to determine the fair price of stock options. Imagine James has the right to buy 100,000 shares of his company at $10 a share, but the current price is $30. That is $2 million in intrinsic value. But the options do not vest for 3 years. In 1997, a spouse might be awarded if, as, and when shares. This meant the spouse had to wait until James exercised the options to get their cut. This kept ex-spouses financially tethered to each other for a decade after the divorce. It created a vesting watch, where ex-wives and ex-husbands would track their former partner's career moves with the intensity of a private investigator, waiting for the day the options hit the money. We also have to analyze the Social Security offset strategy, which gained traction in the late 20th century, particularly in states like Pennsylvania and Ohio. Historically, Social Security benefits are not divisible in a divorce by federal law. If Patricia worked as a stay-at-home mother and James worked a high-paying job, James would end up with a large Social Security check and a large 401k. Patricia might only be entitled to half of the 401k and a smaller spousal Social Security benefit. To correct this, some lawyers argued that the court should look at the value of James's future Social Security and offset it by giving Patricia a larger share of the 401k. For example, if James's Social Security was worth a present value of $200,000, the court might give Patricia the entire $200,401,000 to even the scales. This was a controversial way of bypassing federal law to reach equitable distribution, and it remains one of the most debated tactics in American family law. As we moved into 1999, the cost of living became a major factor in these deep dive calculations. Most 401k plans do not have built-in cost of living adjustments or COLAs. In a divorce settlement, if Patricia received a fixed monthly payment from a portion of James's retirement, that payment would lose purchasing power every year due to inflation. This led to the rise of inflation hedging in QDROs. Savvy attorneys began demanding that the non-employee spouse's share be invested in specific inflation-protected subaccounts. This was the era where financial neutrality experts were first brought into the mediation room. Their job was to project 30 years into the future to see if a 401k split would actually keep a person out of poverty in their 80s. Historical trends show that those who failed to account for inflation in their 1990s divorces are the ones struggling most in 2026. There is also the early withdrawal exception under Internal Revenue Code Section 72(t)(2)(c). Most people know that if you take money out of a 401k before age 59 and a half, you pay a 10% penalty. But in the late 20th century, a specific loophole was solidified. If the money is taken out pursuant to a QDRO, the 10% penalty is waived for the alternate payee. This was a massive strategic advantage. Imagine Patricia needs $50,000 for a down payment on a new house. If she takes it from her own savings, she has no tax benefit. But if she takes it as a cash out from her share of James's 401k during the divorce process, she avoids the penalty. She still pays income tax, but that 10% savings was often the difference between being able to afford a home or being forced to rent. This one-time window of liquidity is something many people missed because their lawyers simply didn't know the tax code. However, this window only stayed open until the money was rolled over into an IRA. The moment Patricia moved the 401k money into her own individual retirement account, the QDRO exception vanished. If she tried to take the money out of the IRA the next day, the 10% penalty was back. This created a step-by-step sequence that had to be followed with surgical precision. If you rolled over the money first and then realized you needed cash, you had just made a $10,000 mistake on a $100,000 distribution. This era of technical gotchas is what defined the financial landscape for the American middle class. But what happens when the 401k isn't just a pile of money, but a tool for corporate control? We have to examine the restricted stock era and how lockup periods created a situation where a spouse could be a millionaire on paper, but have $0 in their bank account to pay for the divorce itself. This leads us to the litigation funding crisis of the late 90s, where spouses began borrowing against their future 401k settlements just to pay the lawyers who were fighting for the 401k. It was a cycle of debt that predated the modern fintech era. As we look toward the final stages of the 20th century, we see the 401k becoming the ultimate ransom. If a participant refused to sign the QDRO, they could tie up the money for years. How did the courts eventually strike back against this administrative obstruction? And what was the secret clause, discovered in 1999, that allowed some employees to liquidate their entire 401k and disappear it before the divorce was even filed? The battle for the 401k was moving from the courtroom to the digital frontier, and the rules of the game were about to be rewritten by the Y2K bug and a new era of federal surveillance. We are entering the dark period of 401k history, where the intersection of technology and greed created the first digital disappearances of marital wealth. As the clock ticked toward midnight on December 31, 1999, the world was obsessed with the Y2K bug, but in the realm of family law and retirement assets, a much more tangible threat was emerging. This was the era of digital disappearance. To understand this phenomenon, we have to look at the technological state of 401k management in the late 1990s. This was the transition period from paper-based accounting to digital ledgers. For the first time, a participant could log into a basic web portal or use an automated phone system to move money between funds with the touch of a button. In a divorce scenario, this newfound speed became a weapon. Imagine a case study involving a husband named Mark, a software engineer in Northern California in 1999. Mark knew that his wife Jennifer was planning to file for divorce. In the weeks leading up to the filing, Mark used the company's new intranet system to systematically shift his 401k investments. He didn't just move money, he engaged in a strategy known as portfolio sabotage. He shifted a $300,000 balance from stable S&P 500 index funds into highly speculative, unproven tech startups that were part of the 401k's brokerage window. This is a crucial detail. The late 90s saw the introduction of the self-directed brokerage account option within 401ks. It allowed participants to trade individual stocks, rather than just picking from a list of 5 mutual funds. Mark's goal was simple but devastating. He wanted the account value to look as volatile and unattractive as possible during the discovery phase of the divorce. By the time Jennifer's lawyer requested a statement, the dot-com bubble had begun to show its first cracks. Mark's aggressive trading resulted in massive paper losses. To the court, the marital asset appeared to be shrinking. However, Mark was betting on a rebound that he would enjoy alone after the divorce was finalized. This was a form of asset dissipation that was incredibly difficult to prove in 1999 because the digital audit trails were not as robust as they are in 2026. Forensic accountants had to wait months for physical confirmation slips to arrive by mail to see exactly what trades had been made and when. This leads us to the hardship withdrawal loophole that plagued many late 20th century divorces. Under the 401k rules of the time, an employee could withdraw money from their account for an immediate and heavy financial need, such as preventing eviction or paying for medical expenses. We saw historical trends where participants would fabricate financial emergencies just as a divorce was looming. Imagine Mark tells the plan administrator he is facing foreclosure on a separate property and needs $50,000 immediately. He takes the distribution, pays the taxes and the 10% penalty, and then hides the remaining cash. By the time the divorce reaches the trial phase, the 401k balance has been depleted. The court might order an equalization payment from other assets, but if Mark has successfully hidden his other wealth or spent it, Jennifer is left with a judgment that she can never collect. The late 90s also introduced the in-service distribution trap. Some 401k plans allowed employees who reached age 59 and a half to move their money out of the 401k and into an IRA while they were still working. In a divorce, this was a strategic nightmare. A 401k is protected by the strict federal QDRO rules we've discussed, but an IRA is governed by state law and transfer into incident to divorce rules. If a spouse like Mark moved his 401k into a private IRA at a local bank without Jennifer's knowledge, he could potentially name a new beneficiary or withdraw the funds with far less oversight than a corporate 401k plan would allow. This was the era where spousal consent forms became the most important piece of paper in a marriage. Before the Retirement Equity Act was fully enforced across all digital platforms, there were glitches where a participant could change a beneficiary online without the required notarized signature of the spouse. Step by step, the legal system had to adapt to these digital vanishing acts. This era saw the birth of the joinder of the 401k plan. To stop the bleeding, lawyers began naming the 401k plan itself as a party to the divorce. This was a radical move. By joining the plan, the court could issue an immediate freeze order directly to the plan administrator, bypassing the husband or wife entirely. This meant that even if Mark tried to log in at midnight to trade stocks or request a loan, the system would flag the account as restricted. However, the administrative lag was still a factor. In 1998, it could take a week for a court order to be mailed, received, and manually entered into the company's HR system. In that week, a 401k could be decimated. Then there was the employer-directed complication. During the merger mania of the late 90s, think AOL and Time Warner, many 401k plans were frozen for months during the transition. If you were divorcing during a corporate merger, your 401k was in a state of administrative stasis. You couldn't get a QDRO approved because the plan was in the middle of changing its legal name and its record keeper. We have documented case studies where couples were forced to stay legally married for an extra year simply because the 401k plan was unavailable for division. This created a massive emotional and financial toll, as the value of the account continued to fluctuate wildly while the parties were powerless to touch it. We must also examine the valuation of the match. In the late 20th century, many companies used a graded vesting schedule. For example, you might be 20% vested after 2 years and 100% after 6. If a couple divorced in year 4, the 401k statement might show a total balance of $100,000, but a vested balance of only $60,000. Lawyers in the 90s fought viciously over the unvested portion. Was it a marital asset because the work was performed during the marriage? Or was it a mere expectancy, because the employee might get fired before they ever see that money? This led to the creation of the coverture formula, specifically for 401k matches, where the court would award the spouse a percentage of the unvested money that would only be paid out if and when the employee stayed at the company long enough to vest. This period was also the zenith of the loan against the 401k, as a divorce tactic. Imagine if Mark, knowing the divorce is coming, takes the maximum allowable loan, usually $50,000, and uses it to pay off his personal credit cards or to gift money to a family member under the guise of a debt. In the divorce, the 401k is now encumbered by a $50,000 debt. The court has to decide if this is marital debt or separate debt. If the court decides it's marital, Jennifer effectively pays for half of Mark's secret spending. This was a way to siphon equity out of the retirement plan and convert it into liquid cash before the lawyers could count it. But even these tactics pale in comparison to the offshore 401k rollover schemes that started to appear in the very late 90s. As the internet made global banking more accessible, a small percentage of high-net-worth individuals found ways to roll their 401k balances into self-directed IRAs that invested in foreign entities or private placements in tax havens. This was the ultimate open loop of the 20th century. Once the money left the US-based 401k system and entered the world of international private equity, the QDRO became a useless piece of paper. How did the US government eventually close these digital loopholes? And what happened when the IRS decided to start auditing these QDRO distributions and found that thousands of people had been using them to avoid taxes illegally? We are moving into the era of the Great Audit, where the mistakes made in 1990s divorce decrees came back to haunt retirees a decade later. In the next part, we will look at the tax recapture nightmare and the lost QDROs that were signed by judges but never filed with the plans, leaving thousands of ex-spouses with no retirement at all. What happens if you discover 10 years later that your ex-husband's 401k was never actually split? The answer involves a desperate race against the statute of limitations that many people are still losing today. The race against the statute of limitations in the context of a 401k split is one of the most harrowing chapters of late 20th American financial history. To understand why this happened, we have to look at the administrative disconnect that existed between the courtroom and the corporate payroll office. In the 1990s, many people believed that once a judge signed a divorce decree, the work was finished. However, a 401k is a creature of federal law, specifically ERISA, and the plan administrator is not a party to your divorce. This led to a phenomenon known as the orphan decree. Imagine a case study from 1994 involving a woman named Barbara. She divorced her husband, Thomas, who had a substantial 401k with a major aerospace company. The judge signed the order awarding Barbara 50% of the account. Barbara's lawyer handed her the papers and sent her on her way. But here is the critical failure. The lawyer never drafted a separate qualified domestic relations order, or QDRO, and never sent it to the aerospace company's plan administrator for approval. In Barbara's mind, she owned half that account. In the company's computer system, Thomas remained the 100% owner. Fast forward 15 years. It is now the mid-2000s and Thomas retires. He logs into his account and sees a full balance because no QDRO was ever implemented to segregate Barbara's share. He withdraws the entire amount as a lump sum and moves to a state with high homestead protections or spends the money. When Barbara finally reaches retirement age and calls the company to collect her share, she is met with the cold reality. There is no money left. This was the lost QDRO crisis. Because Barbara waited too long to enforce her rights, she hit the statute of limitations for enforcing a judgment in her state. In some jurisdictions, if you do not act on a court order within 10 years, it becomes a zombie judgment, legally dead and unenforceable. Historical trends from this era show that this wasn't an isolated incident. It was a systemic failure of the legal profession to adapt to the specialized requirements of the 401k. Step by step, the process required a level of follow-through that the pre-digital legal world struggled to maintain. First, the divorce decree had to mention the split. Second, a specific QDRO had to be drafted using the plan's exact terminology. Third, the plan had to pre-approve the draft. Fourth, the judge had to sign it. Fifth, the certified copy had to be mailed back to the plan for final implementation. If any one of these 5 steps was missed, the entire process stalled. In 2026, we see the descendants of these cases clogging the courts as ex-spouses sue their former attorneys for malpractice or attempt to sue the 401k plans for breach of fiduciary duty, for allowing the employee's spouse to empty the account. This leads us to the tax recapture nightmare of the late 90s. This was a period where the IRS began to scrutinize the way 401k money moved during divorces. Under Section 414P of the Internal Revenue Code, a QDRO must meet very specific criteria to avoid being treated as a taxable distribution. We saw case studies where a couple would write their own informal QDRO to save on legal fees. They would tell the plan administrator to just send a check for $100,000 to the wife. The plan, sometimes through administrative error, would comply. However, because the document didn't meet federal standards, the IRS viewed that $100,000 as a taxable withdrawal by the husband. The result? 2 years later, the husband receives a notice from the IRS demanding $30,000 in back taxes, plus interest and a 10% early withdrawal penalty. He then sues his ex-wife to recover the tax money. She has already spent the money on a new life. This tax ricochet destroyed the post-divorce stability of thousands of families. It proved that in the eyes of the federal government, the intent of the couple mattered less than the precise formatting of the paperwork. This is why the masterclass approach to 401k division became a necessity. You weren't just fighting your spouse, you were navigating a tax code that was designed to be rigid and unforgiving. Another deep dive issue of this era was the anti-alienation conflict. ERISA was designed to prevent creditors from touching a worker's retirement. But in the late 20th century, some people tried to use the 401k as a way to pay off non-retirement debts during a divorce. Imagine if Thomas owed Barbara $50,000 in unpaid child support. Their lawyers might try to write a QDRO that takes $50,000 out of the 401k to pay the back child support. In the early 90s, many plan administrators rejected these orders, arguing that a QDRO can only be used to provide marital property rights or support, not to satisfy a standard debt. This led to a series of federal court battles over the definition of support. The historical trend eventually shifted to allow 401k funds to be used for child support arrears, but only if the document was phrased with extreme care. If the lawyer called it a debt settlement, it was rejected. If they called it alternative support, it was accepted. This was the era of linguistic law, where the name of the payment changed its legal reality. Then there is the issue of the premarital credit. As the 401k matured, people were entering second and third marriages with existing balances. In the late 90s, the burden of proof shifted. If you wanted to protect the $50,000 you had in your 401k before you met your spouse, you had to produce the actual paper statement from the day before the wedding. But in an era before cloud storage, who kept a paper statement from 1982? We saw evidentiary wipeouts, where people lost half of their entire life savings simply because they couldn't prove what they started with. The court's default position was often that all money in the account was marital unless proven otherwise. This created a massive advantage for the non-employee spouse and led to the discovery wars of the 1990s, where lawyers would subpoena old bank basements and microfiche records just to find a single missing balance. We must also talk about the post-separation gains problem. If the divorce takes 3 years to finalize, which was common in contested cases in the late 90s, and the 401k grows from $200,000 to $400,000 during that time, who gets the profit? If the growth was due to the employee's new contributions, it was usually separate. But if the growth was due to the market performance of the marital portion, it was shared. Calculating this required a pro rata analysis that most judges hated doing. This led to the frozen valuation tactic, where one spouse would try to lock in the value at the lowest possible point to avoid sharing the market upside. This was financial chess played with the retirement of the American worker. But the most complex part of this history involves the planned termination scenario. In the late 20th century, companies were being bought and sold at a record pace. If your QDRO was approved by Company A, but then Company A was bought by Company B, and the 401k plan was terminated and rolled into a new system, your QDRO might disappear into a corporate black hole. We are talking about the lost heirs of the 401k era, people who are today in 2026, trying to find which multinational conglomerate currently holds the pension or 401k they were awarded 30 years ago. As we look toward the end of this decade, a new and even more dangerous trend began to emerge: the QDRO fraud. People began creating fake court orders to trick plan administrators into releasing funds early. This led to a massive crackdown by the Department of Labor and a total overhaul of how 401k plans verify legal documents. But how did this crackdown accidentally make it even harder for legitimate divorcees to get their money? And what was the Supreme Court surprise of 2001 that fundamentally changed the rights of a divorced spouse to collect a 401k even if they were specifically removed from the will? The next part of our deep dive explores the Egelhoff conflict, and the moment the Supreme Court told the states that their divorce laws didn't matter when it came to the 401k. We are heading into the era of federal supremacy, where one wrong box checked on a corporate form could override 100 years of state law. The era of federal supremacy reached its absolute zenith with the Supreme Court case of Egelhoff versus Egelhoff in 2001, a decision that sent shockwaves through every family law office in the United States. To understand the gravity of this moment, you have to imagine a scenario that played out for a man named David Egelhoff. David worked for Boeing and had a substantial 401k and life insurance policy. He divorced his wife, Donna, and the divorce decree specifically stated that Donna waived any interest in his retirement benefits. This was a standard, legally binding state court order. Shortly after the divorce, David tragically passed away in an automobile accident. He had never updated his beneficiary designation forms with his employer. Under Washington state law, there was a statute that automatically revoked a spouse's status as a beneficiary upon divorce. It was a common-sense law designed to prevent exactly what was about to happen. However, the case went all the way to the highest court in the land, which ruled that ERISA, the federal law governing 401ks, trumped Washington state law. The court held that plan administrators must follow the plan documents, the beneficiary forms, regardless of what a state divorce decree or a state statute says. This meant that even though Donna had legally waived her rights in a court of law, she still received the entirety of David's 401k simply because a piece of paper in a corporate filing cabinet hadn't been updated. For the American public, this was a terrifying revelation. It proved that in the late 20th and early 21st century, the 401k was a sovereign entity that existed outside the reach of traditional family justice. If you didn't master the administrative bureaucracy of your employer, your legal victories in the courtroom were effectively worthless. This historical trend led to the rise of the administrative audit as a mandatory step in the divorce process. Lawyers could no longer just rely on the judge. They had to become experts in HR record-keeping. We saw case studies where individuals were forced to sue their own ex-spouses to claw back money that the federal government had essentially forced the plan to pay out to the wrong person. The cost of these secondary litigations often drained the very accounts people were fighting over. Step by step, the burden of maintaining the 401k's integrity shifted entirely onto the shoulders of the individual. In 2026, we look back at this as the moment the safety net developed a massive, federally mandated hole. Another deep dive layer of this era was the interplay between 401ks and bankruptcy. As we move toward the end of the 20th century, the economic boom of the 90s left many families with high debt alongside their growing retirement accounts. When a divorce happened, one spouse might file for bankruptcy to wipe out marital debts. This created a legal paradox. If a husband was ordered to pay his wife $100,000 from his 401k as part of a property settlement, could he discharge that debt in bankruptcy? In the late 90s, the answer was often yes. A spouse could use federal bankruptcy law to override a state divorce order. effectively keeping their 401k intact while leaving their ex-spouse with nothing. This led to the 2005 Bankruptcy Abuse Prevention and Consumer Protection Act. But for a decade, the 401k was used as a sanctuary for assets during a messy split. Consider the character of Sarah, a middle manager in 1999. She is divorcing her husband, who has spent years accumulating debt in both their names. Sarah is awarded 50% of his 401k. However, because the 401k is protected from creditors under ERISA, her husband realizes he can file for Chapter 7 bankruptcy. His creditors can't touch the 401k, but his obligation to pay Sarah her share of the marital estate, if it wasn't specifically labeled as support or alimony, could potentially be wiped out. This forced divorce attorneys to start labeling property settlements as in the nature of support to protect them from the bankruptcy courts. It was a high-stakes game of legal semantics where the difference between the word property and the word support was worth a person's entire future. We also saw the emergence of the QDIA, or Qualified Default Investment Alternative complications. In the late 90s, companies began automatically enrolling employees in 401ks and placing their money in default funds, often stable value funds or lifestyle funds. In a divorce, these default settings often hid the true potential of the account. If a spouse had been contributing for 10 years but the money was sitting in a low-yield default fund because they never chose an investment, the marital growth was negligible. This led to imputed growth arguments in court. A spouse's lawyer might argue that the employee spouse had a fiduciary duty to the marital estate to invest the money prudently. While these arguments rarely won, they highlighted the growing tension over who was responsible for the performance of marital assets during the long years of a marriage. The historical data from the late 90s shows a significant spike in post-judgment QDROs. These were attempts to fix mistakes made years earlier. However, the 401k landscape was changing so fast that the plans themselves often didn't exist anymore. Corporate mergers meant that a 401k held at a small regional bank in 1992 was now part of a global financial conglomerate in 1999. The successor and interest rules became a nightmare for divorcees. If you had a QDRO for a plan at DataCorp, but DataCorp was bought by Global Systems, and Global Systems didn't recognize the old plan's vesting schedule, your 50% share might be calculated based on a completely different set of rules. We saw case studies where women, in particular, lost years of service credits because the new parent company refused to bridge the records of the acquired firm. This era also saw the first major battles over loan recharacterization. In 1998, the IRS issued new guidance on how 401k loans should be handled in a divorce. If an employee spouse took a loan and then defaulted, the deemed distribution was taxable. But who pays the tax? If the loan was used to pay for a marital roof, should the non-employee spouse pay half the tax? If the loan was used to pay for the husband's secret gambling debt, should the wife be exempt? The IRS didn't care about the reason for the loan. They only cared about whose name was on the 401k. This created a situation where a spouse could be taxed into poverty by an ex-partner's secret financial decisions. As we look at the complexity of these federal rules, we have to address the missing participant problem. In the late 20th century, it was surprisingly easy for a person to leave a job, move to a different state, and simply forget they had a 401k. In a divorce, if the employee spouse didn't disclose the account, and the other spouse didn't know it existed, the asset was never divided. Years later, when the unclaimed property divisions of various states started growing, these lost 401ks began to surface. But by then, the divorce was long over. How do you reopen a 1995 divorce in 2026 to divide an account that was hidden 30 years ago? The legal hurdles are almost insurmountable, involving fraud on the court motions that have extremely high burdens of proof. The 401k divorce was becoming a battle of endurance. It wasn't just about who had the better lawyer, but who had the better filing system. But as we move toward the final chapters of this masterclass, we have to look at the most controversial tactic of all, the QDRO as a lien. What happens when one spouse uses the 401k not just to get their share of retirement, but as a way to force the other spouse to pay alimony, child support, or even attorney fees? And how did the resegregation of accounts in the early 2000s create a new class of retirement refugees? People who had the money but couldn't access it because of a conflict between the IRS and the Department of Labor. In the next part, we dive into the anti-cutback rules and the moment the government tried to stop companies from changing the rules in the middle of a divorce. We are entering the endgame, where the final survivors of the late 20th century 401k wars are making their last stand in the courts of 2026. The endgame of the late 20th century 401k divorce landscape is defined by the collision of the anti-cutback rule and the aggressive corporate restructuring of the early 2000s. To understand how this impacts a person in 2026, we have to look at Section 411(d)(6) of the Internal Revenue Code. This rule was designed to ensure that once an employee earned a benefit, the employer couldn't simply take it away by changing the plan's rules. However, in the context of a divorce, this created a massive technical paradox. If a husband's 401k plan allowed for a lump sum distribution in 1998, but the company merged in 2002 and the new plan only allowed for monthly annuities, which rule applies to the ex-wife holding a QDRO? Imagine a case study involving a woman named Karen. She divorced her husband, a mid-level manager at a major telecom firm, in 1997. Her QDRO specifically stated she had the right to take her 50% share as a lump sum whenever she chose. But she decided to let it sit and grow. In 2004, the telecom firm was absorbed by a larger conglomerate that eliminated lump sum payouts for all participants to preserve capital. When Karen finally tried to access her funds in 2026, the plan administrator told her she could only receive a check for $800 a month for the rest of her life. Karen argued that the anti-cutback rule protected her original right to a lump sum. This triggered a decade of litigation that highlights the historical trend of benefit stripping. The courts eventually had to decide: is an alternate payee a participant with protected rights, or just a guest in someone else's plan? This leads us to the rise of the QDRO as a lien. By the late 1990s, the 401k was often the only liquid asset left in a marriage. Lawyers began to realize that they could use the 401k to secure other obligations that had nothing to do with retirement. Imagine a scenario where a husband, Richard, is ordered to pay $2,000 a month in child support, but he has a history of erratic employment. In the late 20th century, a judge might issue a security QDRO. This was a legal lien placed against Richard's 401k. If he fell 3 months behind on child support, the plan was ordered to automatically peel off $6,000 from his retirement balance and send it to the mother of his children. While this provided a safety net for families, it created an administrative nightmare for 401k providers. They were no longer just investment managers. They were becoming involuntary child support enforcement agents. Step by step, these support liens changed the math of retirement. Every time a security QDRO was triggered, it wasn't just the principal that disappeared. It was the decades of compounding growth on that money. For Richard, a $6,000 withdrawal in 1999 could represent a $50,000 loss in his 2026 retirement balance. This era taught the American public that the 401k was no longer an untouchable fortress. It was a porous vessel that could be drained by various legal claims before the worker ever reached the age of 59 and a half. Another deep dive layer we must examine is the conflict of laws between the IRS and the Department of Labor. In the late 90s, these two federal giants were often at odds over what a 401k plan was allowed to do. The IRS wanted to ensure every dollar was eventually taxed, while the DOL wanted to ensure every worker was protected. In a divorce, this meant that a plan might approve a QDRO under DOL guidelines, only for the IRS to later declare the transfer non-qualified, because of a tiny technicality in how the alternate payee account was set up. This created a class of retirement refugees, people who had been awarded money by a court, had it approved by their employer, but were told by the IRS that if they touched it, they would be hit with a 40% combined tax and penalty rate. Consider the historical case studies of resegregation failures. When a 401k is split, the plan administrator usually creates a subaccount for the ex-spouse. In the late 90s, these subaccounts were often managed with inferior software. If the original participant, the husband, took a loan against the main account, the software sometimes accidentally lowered the balance of the wife's subaccount too. This led to accounting ghosting, where a spouse would log in to see their court-ordered share, only to find it had dwindled due to the actions of an ex-partner they hadn't spoken to in years. The battle to decouple these accounts was the primary focus of ERISA litigation. As we moved into the 21st century, we also have to address the malpractice tsunami that hit the legal industry in the wake of the 1990s 401k boom. Because 401k law was so specialized, thousands of general practice attorneys made small mistakes that had large consequences. For example, an attorney might fail to include a cost of living adjustment or a pre-retirement survivor annuity, in the QDRO. If the husband died before the wife started collecting, the wife's interest evaporated. In the early 2000s, we saw a surge in ex-spouses suing their own divorce lawyers for the present value of the retirement they lost. This changed the way law is practiced in the U.S. It's why today, in 2026, most divorce lawyers will not touch a 401k and instead force you to hire a QDRO specialist. The do-it-yourself era of the 90s left a trail of broken retirements that the legal system is still trying to clean up. As we look at the data, one of the most shocking trends was the gender wealth gap that the 401k divorce actually widened. While the law said 50-50, the reality was different. Because men in the late 20th century were more likely to be the primary participants and have longer tenures, they often held the separate property credits. A woman might get 50% of the marital portion, but the husband kept 100% of the premarital and post-separation portions. When you factored in the tax liabilities, the actual take-home retirement for many women was closer to 30% of the total household wealth. This was the hidden inequality of the 401k era. It wasn't a failure of the law, but a failure of the math to account for the reality of career interruptions and the tax character of different types of dollars. The final layer of this complexity involves the plan expenses problem. In the 90s, 401k plans began charging fees for processing QDROs. These fees could range from $500 to $2,500. Lawyers would argue for months over who should pay the fee. If the wife was the one wanting the money, the husband argued she should pay. If the husband was the one who made the mistake that required a new QDRO, the wife argued he should pay. In some cases, the plan would simply deduct the fee from the 401k balance itself, meaning both parties paid. This was the death by 1,000 cuts for small 401k accounts. If you were splitting a $20,000 account, the legal fees, QDRO fees, and tax advice could easily consume 25% of the total asset before it was ever divided. This brings us to the final barrier of the 20th century 401k, the early retirement subsidy and the golden handshake. As companies downsized in the late 90s, they offered massive incentives for people to leave early. If a divorce decree was written to split a normal retirement, did the ex-spouse have a right to a piece of the early retirement bonus? This question went to various state Supreme Courts, creating a fractured legal landscape where your potential outcome depended entirely on your zip code. But there is one final, terrifying scenario that we haven't touched on: the plan insolvency of the 21st century, and how it retroactively destroyed the ironclad settlements of the 1990s. What happens when the company you both worked for disappears, and the federal government's Pension Benefit Guaranty Corporation takes over? Does your QDRO still stand? Or are you just another number in a federal database? The conclusion of this masterclass will reveal the survival tactics for those holding legacy QDROs in 2026, and the one document you must find today to ensure your future isn't a historical footnote. We are heading into the final chapter, the Great Reconciliation. The Great Reconciliation begins with a confrontation between the digital archives of 2026 and the paper-heavy bureaucracy of the 1980s and 90s. To survive the fallout of a late 20th century 401k split, we must address the final hurdle: the transition of liability from private corporations to federal insurers. In the late 20th century, the United States saw a massive wave of corporate bankruptcies and liquidations. When a company fails, its 401k plan is typically terminated, and the assets are distributed or rolled into a successor plan. However, for those with a QDRO that was signed in, say, 1994, but not yet paid out, the termination of the plan is a moment of extreme peril. If the plan administrator did not properly record the alternate payee's interest before the company shuttered, that interest could be lost in the transition to the Pension Benefit Guaranty Corporation or a private insurance annuity. Imagine a case study involving a woman named Evelyn. In 1992, she was awarded 40% of her husband's 401k at a regional manufacturing firm. The QDRO was drafted, signed, and supposedly filed. In 2026, Evelyn reaches age 67 and attempts to claim her share, only to find the manufacturing firm went bankrupt in 2005. The records were digitized during the liquidation, but her specific QDRO was never scanned into the new system. This is the data gap that has left thousands of American divorcees in financial limbo. The survival tactic in this scenario is the discovery of the final letter of approval. This is the one document you must find today. In the 1990s, after a plan administrator accepted a QDRO, They would send a formal letter stating the order was qualified. This letter is often the only evidence that survives a corporate merger or bankruptcy. Without it, you are essentially asking a 2026 computer system to trust a 30-year-old memory. Historically, the failure to secure this letter has led to what forensic accountants call the ghost asset phenomenon. We see data from the early 2000s showing that up to 15% of domestic relations orders were never actually implemented by the plan providers because of minor clerical errors that were never caught. If the name on the QDRO was Evelyn M. Smith, but the plan records had her as Evelyn Marie Smith, the system might have rejected the order without notifying the attorneys. This is why the masterclass approach requires a step-by-step verification of the participant ID match. In 2026, we are seeing a surge in nunc-pro-tunc orders, legal corrections that are backdated to the original divorce date, to fix these decade-old typos. But these orders are only effective if the money is still in the account. Let us look at the tax characterization of the final payout. In the late 20th century, the 401k was often mixed with after-tax contributions. If you were divorcing in 1996, your husband might have $100,000 in a 401k, but $10,000 of that was contributed with money that had already been taxed. If the QDRO didn't specify how to split the basis, the after-tax portion, the IRS default was to give the tax-free money to the participant and the taxable money to the ex-spouse. This meant that while the split looked 50-50 on paper, the ex-spouse ended up paying 30% more in taxes on their share. This basis trapping was a common pitfall. To reconcile this in 2026, retirees must look at their original Form 1099, R from the distribution. If the taxable amount box is checked but doesn't reflect the marital basis, you could be overpaying the IRS by thousands of dollars. Step by step, the reconciliation process in 2026 requires a three-pronged audit. First, you verify the service credits. In the 1990s, many 401ks were tied to years of service for vesting purposes. If you were awarded a share of the retirement, you were also supposed to be awarded a share of the vesting clock. We have seen historical trends where a spouse was given the money but not the service time, meaning if they tried to roll it over, they were hit with a vested percentage penalty. Second, you must audit the dividends and interest from the valuation date to the transfer date. If the court ordered the split in 1998 but the money didn't move until 1999, you are entitled to the growth during that year. In a bull market like the late 90s, that growth could be 20% of the total value. Third, and perhaps most importantly, is the beneficiary cleanup. As we discussed with the Egelhoff case, federal law is ruthless. If you are a divorcee in 2026 and your ex-spouse has recently passed away, you may find that their new spouse is claiming the entire 401k despite your 1990s divorce decree. The Great Reconciliation has led to the rise of interpleader actions, where the 401k plan takes the money and drops it in the lap of a federal judge, saying, "We don't know who to pay, you figure it out." This results in years of legal fees. The only way to prevent this is the certified QDRO on file check. You must call the plan administrator and ask them to read back the alternate payee designation currently in their system. If they don't have your name, your court order is just a piece of paper. This era of American history was a massive experiment in individual responsibility. We moved away from the collective security of the pension and into the individual volatility of the 401k. For divorcing couples, this experiment was often cruel. It required them to be investment bankers, tax attorneys, and forensic accountants at the exact moment their personal lives were falling apart. The potential outcomes, for those who succeeded, were a stable, middle-class retirement. For those who failed, the outcome was often hidden poverty. People who worked for 30 years and have nothing to show for it because of a missing signature in 1995. Imagine if the United States had stayed with the pension system. The 401k divorce would be a historical footnote. Instead, it is the defining financial event for the baby boomer generation. As we reach the conclusion of this deep dive, we have to recognize that the late 20th century isn't just a time period. It's a set of rules that still governs your bank account today. Every dollar in a 401k has a history, and in a divorce, that history is either your greatest asset or your most dangerous liability. The story of the 401k divorce is ultimately a story of the missing billions. There is an estimated $20 billion in unclaimed or improperly divided retirement assets sitting in the U.S. financial system right now. Much of this belongs to the alternate payees of the 1990s who simply gave up or didn't know how to navigate the QDRO maze. The Great Reconciliation is about finding those billions. It is about the audit of the soul, as much as the audit of the account. But as we look at the legacy of these splits, a new question emerges. As the 401k generation begins to pass their wealth down to their children, how do these 1990s QDROs impact inherited IRAs? Can a child inherit a QDRO interest from a deceased mother that was originally a marital interest in a father's 401k? The chain of title for American retirement is becoming more fractured than ever. And in our next series, we will examine the next generation wipeout, how the mistakes of the 1990s 401k divorce are now destroying the inheritances of the 2020s. If you think the battle for the 401k ended with the divorce decree, you are only half right. The real war for the family legacy is just beginning. What happens when the alternate payee becomes the deceased participant? The answer will change everything you thought you knew about the stretch IRA and the future of American wealth.